Hi, my name's Grace. I'm a criminal defence solicitor and I work at a firm called Commons. This video is aimed at anyone who supports young asylum seekers and refugees. My goal is just to give simple, practical advice on how to make sure that the young people you support have access to a free or heavily subsidised legal representative at all stages of the criminal justice system. So from the police contacting them right through the court process. The first time most people want a criminal defence solicitor is after being told by the police that they want to interview them about an alleged crime. Now, this can either be done under arrest, with the young person held in police custody at a police station, or by the young person voluntarily agreeing to attend the interview. Now, I put voluntary in quotation marks here because it's a little bit misleading. If the young person doesn't agree to be interviewed, often the consequence is that they're arrested in order that they can be interviewed anyway. So the young person's choice is not really about being interviewed or not, but rather about how they're interviewed. In either case, arrested or there voluntarily, the young person is entitled to a free and independent lawyer. Their immigration status, their age, their wealth, it's all completely irrelevant. At this point in the process, at the police interview, literally everyone is entitled to a free lawyer. I'll start with voluntary attendances. These are offered when the police decide it's neither necessary nor proportionate to arrest the young person in order to interview them about an alleged crime. This usually applies to older or less serious allegations. I guess because the police aren't worried that the young person might run away or destroy evidence or give the heads up to other people they think are involved. The voluntary interview process will start with the interviewing officer calling or writing to the young person or even showing up on their doorstep in order to establish two things. A, is the young person willing to be interviewed? And B, if so, when in the next week or so can they do it? And a voluntary interview usually takes place at a local police station in a room designed for this purpose. During that interaction, the police officer will ask the young person if they want a solicitor. If they say yes, they'll follow that by asking for the contact details of the particular solicitor they want. And if they don't have a particular solicitor, then they offer them the duty solicitor. A quick word here about duty solicitors. They often get a bad rap, which is usually unfounded. Admittedly, I would say that because I spend part of my time being a duty solicitor. So do most criminal defence solicitors representing legally aided clients. To be a duty solicitor just means you have an extra qualification which gets you on the rota of local courts and police stations. And then when someone is arrested or at court or needs to be interviewed and they don't have a named solicitor who they can call on, they get you. Being on the rota doesn't mean you care less about that client or you don't have enough clients of your own, just part of doing the job. So a bit like a doctor maybe who does NHS and private work. So if you find out that your young person's been represented by the duty solicitor, don't panic. It's wrong to assume that they haven't been properly represented. Having said that, it is true that some young people, especially the young people that have gone through the kind of trauma that many young refugees and asylum seekers have, will feel more comfortable, more at ease, more willing to be honest with solicitors who come recommended by other people they trust, or who they know have some kind of expertise in areas that relate to them, like the crossover between immigration and crime, or immigration offences, things like that. If that's the case, neither you, as the person advocating for the young person, or the young person themselves, should feel unduly pressured into sticking with a duty solicitor, particularly at an early stage in the case where very little or no work has been done. Right, let's go back now to voluntary interviews. So, as I've said, the officer will offer the young person a solicitor when they first make contact. Now, it's fine if the young person doesn't know the name of the solicitor they want there and then. They just tell the officer that they'll ring them back with this information. You and they then find a solicitor of your choosing, and that solicitor can take over liaising with the police and find a time and date for the interview that suits everyone. It's also not a problem if the young person first of all asks for a duty solicitor and then changes their mind. You or they or the new solicitor you instruct can just contact the officer and explain that the situation has changed. And so long as that duty solicitor hasn't spent lots of time engaging with the client on this matter, or is already travelling to the police station, they're not going to have an issue with handing the case back. Most importantly, the young person can always change their mind about whether they want a solicitor at all. Even during the interview, they can ask for it to be paused so that a solicitor can be brought down there and then. When a young person is arrested and brought to a police station, the custody sergeant asks them the same question as the interviewing officer asks them when they're voluntarily interviewed. Do you want a solicitor? Now, if the young person doesn't speak enough English to understand those types of questions, then the police shouldn't sort an interpreter. But still, it's a high-stress situation, it can be rushed, the young person might not be making the best decisions. They might, for example, think that asking for a solicitor makes them look guilty, or that it will keep them there longer. So that's why it's really important that when you're with the young person in a safe environment, you drill into them how important it is, if they should find themselves in this situation, to take up the offer of legal advice. If they do that, then the custody sergeant will then ask them for the full name, or firm name at least, of the solicitor that they want to represent them. Now, even if you've given the young person this information in advance, chances are that in that moment they're going to have forgotten it, and they can't just immediately ring you up and ask you to remind them. And if they can't recall enough details about that solicitor, then the police aren't going to be able to track them down, so they'll end up with a duty solicitor. There are a couple of ways of avoiding this, if that's what the young person wants. The easiest is just to make sure they always have this information to hand. So they could save it on their phone. The problem with that is that the young person may not want to give the police access to their phone until they've had legal advice. So it's a bit of a chicken and egg situation. Might be better just to make sure they have a bust card in their wallet, or a bit of paper with the solicitor's name and number that they can stuff behind their phone case. Alternatively, if you find out on the day that a young person is in a police station, even if they've been there a few hours already, you can call up a solicitor you trust, and that solicitor can then ring the custody suite and get a message to the young person through the custody sergeant to say that you've recommended them, that you think they should have a lawyer, and that young person can then decide to swap from the duty solicitor to the person that you recommend. Obviously, it's their choice, but as long as the duty solicitor hasn't already started the case, so hasn't gone to the police station, started the interview process, they should be fine with handing the case back. Securing representation for the young person at court is unfortunately a little bit more complicated. That's because an application for public funding, also known as legal aid, will need to be submitted. Now, if they're under 18, they'll automatically qualify for the means part of the applications test. But if they're 18 or over, their average income will need to be below a certain threshold in order to qualify for a free or subsidised lawyer. And that threshold varies depending on the type of court their case is going to be heard in, or whether they have any dependents or significant outgoings. These are all things that the solicitor can explain in more detail. Now, if the person is receiving state benefits, then the process is pretty simple. Usually the solicitor will just need their national insurance number or the number on their ARC card. Also, don't worry if they've not currently got formal immigration status and therefore aren't receiving any income at all. Perhaps they're staying on friends' sofas or waiting for their benefits to come through. We can just put all that on the form. If they've got a job, or if they're self-employed in particular, it becomes a little bit more tricky, as we do need to supply the legal aid agency with proof of their incoming and outgoing expenditure. So, for example, things like wage slips, bank statements, rental agreements. And until the application is submitted, the solicitor's got no guarantee that they're going to be paid. So usually this all needs to be done well in advance of the first court hearing. If the young person needs an interpreter in order to communicate with their solicitor, for example, to receive advice on the strength of the evidence, then that also can't be funded until the legal aid application has gone through. It follows, of course, that there's no funding for an interpreter to actually complete the application itself. So if you speak the young person's first language, or you can source someone who's willing to act as an interpreter at that point, that help can be invaluable to the solicitor and the young person. You might be thinking at this point, what do we do if the young person is held in custody and goes straight there to court? How are they able to access things like bank statements and wage slips without even a phone they can use? Well, the answer is that the solicitor may well have to take it on faith that that young person will qualify for legal aid and will provide those documents down the line. Perhaps when they're released on bail or through friends, family, you all supporting them to get that information whilst they're in custody. If that can't be done, or if for some other reason legal aid can't be sorted before the first appearance, then there is again the backup option of using the duty solicitor. Again, there'll be an experienced solicitor who's on the rota and randomly assigned that client on that day. The second hurdle to accessing free representation at court is something called the interest of justice test. Essentially, the government won't pay for your criminal defence solicitor unless they decide that justice demands you have one. And usually this turns on the seriousness of the offence that the young person's been charged with. So if they're staring a prison sentence in the eye, then very likely they'll pass this test. But on the other extreme, if the most serious sentence they could be given at the end of everything is a fine, then likely they won't. So less serious driving offences, for example, no insurance, are unlikely to result in the young person getting a free lawyer. However, don't give up. Always check with their chosen solicitor because other factors can be relevant. For example, mental health issues, learning difficulties, a complicated defence, or just the fact that the young person's never been in trouble before can all be reasons to justify passing the interest of justice test. So now you know how to make sure that the young person has a lawyer in court, but how do you make sure they have the lawyer they actually want? This all turns on something called the online declaration. It looks like this. It's a form that the young person signs, essentially confirming to the legal aid agency that they want, among other things, that particular solicitor to represent them. Now, solicitors often have clients sign these in the police station, even if there's no prospect of them being charged straight away, so it could be in weeks or months' time. The reason for that is simply to allow legal aid to be applied for quickly once they are charged, without, for example, them having to attend the office if they live far away. That's all fine if the young person wants the police station solicitor and the court solicitor to be the same person. If they don't, then they need to let the police station solicitor know this before they are charged, because after they're charged and legal aid is applied for and granted, it's really difficult to transfer solicitors on a legal aid representation order after that point. More about this on the next slide. On the other hand, I wouldn't necessarily recommend that the young person cut all ties with the police station solicitor at this early stage. That's because if the police decide they want to interview them about the same allegation again, perhaps new evidence has come to light, then it will be the original police station solicitor who's funded by the government to attend. An alternative, a kind of halfway house, would be for the young person just to email that original police station solicitor and say, look, if I'm charged, please could you have a discussion with me about it before you submit the public funding application. And that then gives the young person a bit of breathing space, a grace period, between being charged and going to court, when they can decide, do I want to stay with that solicitor or do I want to hunt around for another? If the young person has ended up with legal aid with a firm they don't want, there remains the option to transfer to another set of solicitors. However, this does involve an application to the court, and these applications are rarely granted. In order to do so, the judge needs to be convinced that the relationship between client and solicitor has completely broken down. So general complaints like poor communication, vague advice, or just not being the young person's first choice are rarely going to succeed. Bearing that in mind, it's important that in your efforts to make sure the young people you work with have access to the best possible solicitors, you don't accidentally sour the relationship between that lawyer and young person in circumstances where they may be stuck with that representative until the conclusion of their case. So although it's ultimately a question for your own professional judgment, I'd suggest you consider whether your efforts are better placed improving communication between that young person and solicitor, helping the young person to express their concerns, and also holding that solicitor to account where appropriate. And I would just say that while there's never an excuse for bad communication, it is true that sometimes in criminal defence, less is more. Sometimes not chasing the police for an update in the investigation, allowing things to remain quiet, can be in the client's best interest. And this may be very different from other legal contexts you've been involved in, like immigration or housing or community care, where the young person solicitors might appear more proactive. I hope that this video has been helpful. If you want to access a space where you can pose questions or share thoughts and advice with other professionals, legal and non-legal, working with young asylum seekers and refugees who are criminalised or risk being criminalised, I would encourage you to join the community of practice set up by Commons and the Migrants Law Project for this very purpose. I will share details for how to access our community of practice with this video.